Okay, so um, we are here to look at practical steps for the supply chain. Myself and Rachel McDonald will be running through this with you and dealing with a whole range of issues. So, Rachel, if you provide a bit of an intro overview of what we'll be talking about this morning.
Sure, thanks very much, Jess, and hello and welcome to everyone joining today. By way of introduction, my name is Rachel McDonald. I'm a partner in the commercial disputes team here at Mills and Reed, with a focus on food and agricultural disputes. And we're talking today about supply chains. So why are we talking about supply chains issues? Well, actually, that could be fairly self-evident, from delayed deliveries to higher prices to empty shelves in supermarkets. Vulnerabilities in the supply chain have rarely been out of the press in recent years. And I've actually just a few minutes ago come up from a speech that was given by the Governor of the Bank of England, who visited our Norwich office today to speak to us and several of our clients. And the way he framed it was talking about it in terms of a number of different demand and supply shocks, all of which have had an impact on supply chains, starting with COVID, pushing up the price of goods, into the war in Ukraine, pushing up energy prices, and then the effect on food, which he said it was at one point as high in terms of inflation of 20%, now sitting around 12%. And then finally, a domestic shock with labour supply shortages issues also significantly hampering the supply chain. And this, he said, is a continuing issue and one that may take many years to resolve. So what we wanted to do to talk to you about today is, bearing in mind all of those factors and all of the difficulties in supply chains, was to talk about managing those risks. And so Jess is going to talk to you about how to risk manage a supply chain to try to avoid problems, disputes and crises occurring in the first place. And then I'm going to talk about some practical steps to consider if all else fails. So if Jess's measures don't work, then and disputes do arise, thinking about your contractual rights and remedies, how those rights can feed into negotiations, and finally ending with some very general but always useful early dispute risk management steps. So Jess, do you want to move on to talk about de-risking the supply chain?
Thank you. So my background is in the food product liability, food regulatory side. And one of the aspects that was really important, I helped Professor Chris Elliott with his review of food supply chains back in the time of the horse meat contamination saga. And one of the clear points was how important it was to risk assess, to provide those food regulatory processes to the entirety of your supply chain. The sort of hazard analysis, critical control points. Where were your weaknesses? Where were your pinch points? Where were your vulnerabilities within the entirety of the supply chain? What we found with the horse meat contamination was it wasn't those food businesses that carried out testing and audits and checks throughout their supply chain. It was those that didn't provide so much regular testing, didn't require the same amount of audits, who were most likely to be targeted. So, as with any risk, it's really important to look through and think, where are those vulnerabilities? And it normally is where there is an exchange happening within the supply chain. So it would be at the point of procurement from your suppliers. It would be at the point of processing, it would be at the point of delivery to customers in particular, where there will be these sort of pinch points and vulnerabilities. And so it's so important to look at this as an individual based business in your individual products, to look and see sort of where are the hazards, what are the hazards, where's the likelihood of them occurring, and so what can I do to mitigate the risk, to reduce the risk of anything going wrong of these hazards. So if I run through these very broadly, it will differ according to each individual business, but it will give you a bit of a flavour as to what you might do, handy hints as to how you can manage your own supply chain in this way. So looking at the initial point of the supply. Now, this will depend, again, on the food. It can be a very simple supply chain, or it can be much more complicated where you've got a more processed food product. So looking first of all, food fraud, you would never expect it. But again, it will depend on the environment that you're in. The horse meat contamination happened because the price of beef rose just as the price of wild horses was falling in a certain part of Europe. And so that then created the environment where it was in criminals' interest to commit fraud. And you can find this with a number of ingredients, whether it's particular spices or particular varieties of rice. And it's really important to keep those checks and balances in place, but also to be aware of if there was perhaps climate change or some sort of flooding or some other issue that might relate to a contamination point, and to ensure that your processes are proactive and robust enough to respond. It's always going to be about supply and demand, and there are a variety of differing aspects that will affect this. A lot of this will be out of your control. However, if you are prepared for the fluctuations, then you will have more chance, not an absolute chance, but more chance of being able to respond at least ahead of your competitors. And it has been a massively fluctuating environment, as Rachel mentioned. One example would be the carbon dioxide, where you have the energy prices hit onto the fertilizer, which then hit onto the production of CO2, and the impact of that across the brewing industry in particular. So it may not be immediately straightforward, the consequences. So this is where you drill down to understanding what your supply is needed for, what the alternatives are. So is there a similar but different ingredient that you could use? Are there other suppliers that you could use? Have you put in the sort of the background, the audits, the tests, the checks on them in advance, so that you're not starting from a blank page? And this will again depend upon your own recipe and your own claims that you have made about the product. In particular, if you're making any free from claims and an alternative factory or your current supplier has changed their requirements, then how quickly will your labelling be able to respond to that? Because as a food safety issue, you will have to be very quick, and would there need to be over-stickering? How clear are you on the audits and the tests that you carry out? Another really important aspect that it is gaining more and more importance in recent years is also the corporate sustainability reporting. And this will be throughout the supply chain. There are regulatory requirements on corporate sustainability reporting that are coming in Europe, and UK will not be too far behind, and quite a lot of food businesses do this on a voluntary basis in any event, and there are some mandatory requirements, such as in relation to modern slavery statements, where you are above a certain size. I believe it's 36 million turnover globally, and a location in the UK. So wherever you go with organising your supply of products into your business, this will affect the entirety of your supply chain. It will affect the end labelling, and it will also affect your end customer as well. And other aspects to be aware of in relation to what is going to affect your product, what is going to affect your supply, will also be the availability of product and the price in relation to trade deals. Now I've got the helpful, i.e. eggs here, and this was one example where the price of eggs has fluctuated so enormously, and the regulatory restriction on battery chickens, when that came into the EU, it caused a spike of 75% on the price of eggs. This really impacted that whole sector that would use eggs as an ingredient, cakes and biscuits. And it really caught them on the hop, so to speak, because they hadn't actually being so aware of the impact this would have on their own supply into their products. And we're still seeing the fluctuations in the price of eggs. We've got the transatlantic trade partnerships, DP. I always get the letters wrong here, but the Comprehensive and Progressive Agreement for Trans-Pacific Partnership. Now, this is going to phase out tariffs on eggs and egg products over a 10-year period, and they do allow conventional battery cage systems within those countries. So there is an outcry from the egg industry where they're saying we have these particular welfare standards, and this is being phased out. At the same time, the EU is proposing by the end of this year to deliver a phasing out of caged farming before banning the practice altogether in 2027. And certain member states do this already. So on the one hand, we've got a restricting of the market within Europe and the UK, and on the other, particularly in the UK, we've got a lowering of the tariff. So it's very important to be aware of the environment, be aware of the likely fluctuation of prices in relation to your own ingredients as a food company, as well as where do your products actually sit themselves. It's so important to know your product, know the sector, where is the threat, where is the opportunity. So there are certain food products where this is more important than others. If your product falls within the category of a food which is high in fat, salt, or sugar, then that is something to be immediately aware of as to the constantly changing obesity strategy and the restrictions on marketing, and also any future changes in the labelling of that. If you're in the health and nutrition side of things on the labelling front, then that's really important to understand where the legislation is on that. Novel food in particular, we're seeing the Food Standards Agency has provided advice on cannabinoid products and the guidance level, and this came as a real shock to the CBD industry, that which was on the permitted list. We had Holland and Barrett clearing their shelves about a week later, then putting the products back. But still, this is where the guidance from the Food Standards Agency front can really affect your sector in whatever way it is. They might have another a piece of guidance on something else that would then affect your product. You can't horizon scan for everything, but you can certainly be aware of where the risks are. And again, with the UK wine reform, we are having massive changes coming in that's really going to affect that sector too, as well as looking at your own processes. We've talked about HACCP of the entire supply chain, but obviously HACCP of your own processing, but not just in relation to food safety, but also looking at the workforce, looking at innovation, looking at waste reduction, because as a byproduct, if you like, of this scrutiny within your own processes will be that you will be more aware of alternatives, you'll be more aware of how to reduce waste, and you'll also be more open to innovation. And on the flip side, you'll be ready, more ready for any business interruption and how to actually sort of manage a crisis, to sort of understand how you would respond, how you would find your alternatives for any business interruption. And finally, in relation to your products, sometimes most importantly, actually, is your presentation of them, what you actually say about them. It can be a unique selling point. It can be the aspect that adds a premium to your product, which when you have sort of the basic cost of food, adding any premium is so crucial, as well as the impact on the brand itself. So these claims, these labeling issues, the sort of voluntary claims, particularly the green claims, sort of claims of any origin, is really going to affect where your supply is from and what you can do with your product itself, whether you're changing of your processing location or anything like that. It will all have an impact. We mentioned there's a free from claims before. There's also organic claims. Anything that you say about your product, you'll need to substantiate it, and it can't be misleading to the consumer. And this is particularly so in relation to green claims, where we've seen such a focus on that over recent years. And finally, from my point of view, looking at sort of where the product is going, your customers, being aware of all aspects of the product through the supply chain, including packaging and plastics. Now, there's further regulation coming through. We've seen it in the sort of single-use plastics in the UK, where there has been exceptions carved out of that. So it is more limited than what was thought to happen. But in the same way, we have got European regulation coming through, and that is going to be much more restrictive and likely to be replicated, particularly by food business customers who are larger, so across the EU and UK. The other thing, again, is the importance of data. If not yourself, then your customers will most likely have corporate sustainability reporting, whether that's mandatory or voluntary. And data is really valuable. It's really important to collect that through the food supply chain. It will add that extra value to your customers, whether you can monetize that or not, or whether it provides you the competitive advantage. Data is getting more and more crucial to the food supply chain. And then the route to market. Are you direct to consumer? Are you business to business? This will affect your regulatory burden and what it is possible to say, not say about the product, how you will package it, a whole route of different things. So that needs to be sort of like an actively made decision, looking at the pros and cons of each, or if you want to sort of expand into the different areas, the opportunity that might be there for you. Location of customers. We're seeing the effects of Brexit. We're seeing the Windsor framework. There are further regulatory requirements coming in on the Windsor framework, for example. Do you want to have your goods in the red channel to be able to go across into the EU as well? Or are you happy to have the speed and convenience of the registration for the green channel, in which case there might be additional labelling requirements and we're going to be seeing that over the coming years, that will be expanding across a whole range of food products as well with the not for EU. But most importantly, underneath all of this is not to overpromise, to ensure that your costs, that your quality, that what you're saying to the customer, that you can actually provide. And this is where Rachel will come in as providing an overview of the contractual obligations and how to work through those. Many thanks.
Thanks ever so much, Jess. That's given us a lot to think about. What I want to do today is just use some illustrative examples, mainly around failure to supply goods, to show how the contractual framework often works. So just starting with a bit of a health warning, every contract is going to be different, so it's always preferable to seek legal advice before taking action. And today we're considering the position under English law, although I suspect many of you have supply chains that span different jurisdictions. If that's the case, then there may be a different law that's applicable to your company's situation. So it's really important to check those provisions. You can see on the screen there, I just wanted to provide a very simple supply chain as an example. We've got three parties, A, B, and C, although in practice, the supply chain will probably go far beyond that on both sides. That's what makes it so complex. But for present purposes, we'll say C provides apples to B, B then manufactures those apples into pies and sells on to A. And the question really here is, so what happens if company C starts providing the organic apples late or not enough or not at all? And the first place to start is, well, what are B's rights under the contract? Just moving on to the next slide, there may well have been a breach of contract by C. And if there has been that breach by failing to deliver, and that's caused company B to suffer losses, then that company may well be entitled to recover damages. But really the question is, how is that going to help company B right now to get company C to deliver on time? And whether there are any more practical remedies. For example, if company C is in breach, does company B have the right to substitute new suppliers? And you can see an example delivery clause on the slide right now, and we'll walk through that in a minute. Often there's some form of penalty-based system, which means that smaller breaches, smaller failures to deliver or delays can count cumulatively to enable a more significant or clearer relief or financial penalties. And then finally, does B then have a contractual right to terminate? For example, if C fails to deliver the goods on time, and time is expressed to be of the essence, then B may well have a right to terminate the contract for material breach. So just looking at that example delivery slide there, here you can see what your legal rights are. If you're the customer, you can see at the top of that clause lots of provisions about how delivery must be performed. And you can see at 1.4, delays in delivery of over 2 hours without limiting any other rights will entitle the customer to refuse to accept those deliveries, obtains substitute produce, and recover from the supplier those expenses that have been reasonably incurred in doing so, and then also claim damages for any other costs. So those are your legal rights if you're the customer in that example situation. The question again, though, is really need to think about the practicalities of those rights. So does B actually have any alternative suppliers lined up, and can it just switch suppliers so easily? Perhaps that goes back to some of the things that Jess was talking about, and whether you need to sort of diversify your suppliers to ensure that you've got options. If C is struggling, the chances are that other suppliers may be too, particularly in the food and agri sector. There may be issues across the board that are causing the problems. So, for example, poor harvests. And it's also difficult to purchase goods at short notice due to grow times. So crops in the ground are most likely already accounted for, and switching suppliers not also always possible. And then, not to be the doomsdayer here, but claiming damages is fine, but there's a long lead time in doing that, and there's a lot of work involved in recovering those damages on occasion. It doesn't actually get you out of the problem that you're in at the moment. And so in practice, all of those rights that you can see on the slide there, if we move to the next one, all of those rights may really be methods by which B can exert pressure on C to start performing its contractual obligations. And how those negotiations are approached really depends on the relationship between B and C at that time and how much pressure is needed. Sometimes we recommend that clients look at the dispute resolution provisions in their contracts, because more and more regularly they will provide a mechanism without court proceedings for seeking to resolve disputes. So, for example, principal to principal negotiations are actually contractually obliged and written into the contract, so you can use those to force the other side to come to the table. Bearing in mind, though, that C may well be in financial difficulty, what you're really thinking about is what's the middle ground here, and can you renegotiate, or reach an agreement, which may involve, for example, deferring performance or payment, or reducing deliveries for a period whilst things even out. And that's a lot to consider. But what it boils down to, really, I think, is if you're reluctant to start legal proceedings, as many of our clients are, what can you use in the contract to bolster your negotiating position? And just then moving to the next slide, because it's all too easy to focus down the chain and issues with your supplier. But if you're that company B in the middle, then it's likely to be causing you issues with your onward contract, because B now in breach of its contract with A. It wasn't able to onward supply the products. And from that perspective, you're really just looking at similar issues from a different angle. So therefore, what's A going to be looking at in terms of its right under the contract? Can it terminate? Can it sue for breach? Can it substitute suppliers? If they are going to use a substitute supplier, just as in the example clause I showed you a moment ago, are they then able to recover any additional costs they've incurred from B? And again, one of the key questions is how you approach A about those issues. And really that depends on the strength of the relationship and how much you can talk about the issues down the chain as causing the issues you've now got in your contractual relationship with A. Because what's really important in these supply chain relationships is that ultimately the remedies almost always need to flow through the contractual chain. So in this scenario, just because C is the one causing the problems, that's not necessarily going to help company B in its dealings with company A, because the contractual relationship is with B and C on one hand, so B can recover damages from C or has rights against C, and A and B on the other. And so B is, to some extent, slightly stuck in the middle. Moving on to the next slide, looking at cash flow issues. So the next slide is about solvency issues, which are a really hot topic at the moment. As you know, measures designed to support businesses during the pandemic have pretty much totally been removed. And in our firm, we're really starting to see an increasing number of companies experiencing financial difficulties, and that then causes issues in the supply chain. I'm going to consider some issues that relate to companies that are having cash flow problems. There, the risk is that the supplier will enter some sort of, or the company in the middle here, company B, will enter into some sort of formal insolvency process, and that can create problems for the supplier and the customer on either side. They either find themselves out of pocket or unable to secure the supplies and the goods that they need. What we don't have time to cover in this session today is how to deal with the party that enters into a formal insolvency process, so administration or liquidation, for example, as then matters can accelerate quite quickly and they're necessarily quite fact specific and it's largely about how you deal with the insolvency practitioner that's been appointed. But I do just want to touch on a few issues, considering an example where company B is having cash flow problems. Here, both A and C will have an interest in trying to protect their position. If B's cash flows issues become critical, it won't be able to pay C for the supplies, and it might not be able then to service its contracts to A. It's always important in these scenarios to really think about the red flags that might signal that a party in your supply chain is having solvency issues. And these, for example, can include longer lead time for payments, or failure or delays on delivery, pressure to satisfy invoices, or in some occasions, goods that are below the quality that you would expect or are entitled to. Now, once you're aware of B's position, and we do see this quite regularly at the moment, A and C may well want to take a pragmatic view. Is it better to flex the contractual arrangements in order to continue maintaining that supply chain rather than to allow a key supplier or customer to fail? And we have seen a number of examples of, the companies around company B propping up company B until such time as they can put in place other arrangements. one clause that can help if you were company C is whether your company has a what's known as a retention of title clause or an ROT clause, and that's provision provides that title is retained by the seller, in this case C, until such time as B has paid for the goods. So ownership of the goods rests with C until payment is received. A retention of title clause can be supplemented by additional provisions as well regarding how the goods are to be treated. But you can see an example of that sort of clause on the next slide, where it says the company. Moving on to the next slide. The company will, the supplier will not goods to the title to the goods will not pass until the supplier has received payment in full for any of the goods, or if the customer has resold the goods. A health warning, because a retention of title clause is not a guarantee that C can recover the goods in the event of B's insolvency. They can be quite difficult to enforce, but they do again offer a degree of protection against B in the event of non-payment. Although, of course, in this sector, if the goods you sell are perishable, as is often the case, or have a short shelf life, or if they're highly bespoke, then a retention of title clause may be of limited practical assistance. One question we often get asked is whether the contract allows, in our example, C to withhold delivery if it doesn't get paid by B, so for future goods. Again, that's a case of referring to the contractual terms. So don't assume that non-payment means that you can reclaim the goods or refuse a further delivery, because actually doing so could well put you in breach of the contract yourself. And finally, on solvency issues, a word of warning: many contracts, in particular those drafted before 2020, contain a clause providing for the insolvency of a party, broadly defined as entering into a solvency procedure, being grounds for automatic termination. So if a party enters into an insolvency procedure, then the other party is automatically, the contract automatically terminates. Just be really careful of these clauses, because the recent Corporate Governance and Insolvency Act, or CGA, means that actually they are not automatically affected. I wanted to just finish off on the next slide with some practical tips, because a lot of what I've focused on is around negotiations when disputes first arise. And in these early stages where matters are going wrong, it's really important to think about protecting your position and also actually giving yourself a competitive edge if matters do escalate to a formal dispute. So in terms of practical steps, number one, be careful what you put in writing. I say this because if matters progress and court proceedings are commenced, then it's likely that relevant documents, whether helpful or unhelpful, will need to be disclosed to the other party. You have no idea how many times we get to that stage in proceedings with clients only to find that someone has written something really unhelpful to their case, and that can often change the whole landscape of the dispute. So before you put pen to paper or start typing, just think about how would this communication look later down the line. The second one is speak up about various breaches and keep a record of them. If you say nothing, the other party might rely on that as evidence that you've waived your rights. Also, contemporaneous records of losses suffered by you will become really important evidentially going forward. Thirdly, so far as possible, continue to comply with your own contractual obligations and take steps to minimise your losses. And in supply chain contracts, you can see how that plays into trying to obtain goods from a third party, for example. Again, this is all looking further down the track. You won't be able to recover losses to the extent that you could have taken reasonable steps to minimise them. In any negotiations, be clear about what is and what is not legally binding. As I said earlier, when you're in negotiations and if you're letting the party stray from their contractual obligations, it's really important to make clear what the basis of that concession is, and whether it's time limited or a one-off arrangement, for example. Because if you don't, there's a risk that later they will say, well, this was just the series, this was the status quo from now on, and you might find it difficult to go back to your strict contractual obligations. Don't run out of time. Some contracts contain specific deadlines for notifying of claims or commencing proceedings. There are also statutory limitation periods that might be relevant. You don't want to seek to make a claim or make allegations and then suddenly find that actually you've lost the time to do that. And finally, and definitely not lastly but leastly, if you are attempting to settle a dispute, use without prejudice. Make sure that any negotiations or offers are expressed as being without prejudice, and that means that you can at least to some extent freely discuss the matter without the other party subsequently using those discussions at a later stage as evidence of or admissions of any admissions or concessions. A word of warning though, and I expect you know, in any negotiations, simply just because you've said without prejudice, once you've made that concession, the other party knows that you've made it, and that's how you think. So you do have to nevertheless be careful in negotiations. But that, I think, finishes my section on contractual remedies and early steps. I've got one question here that it might be worth me just picking up on now. We get this question quite a lot, and we got it a lot during the COVID pandemic, which is, can I not rely on what's known as a force majeure clause? And often contracts contain force majeure provisions. They're usually defined, for those of you who don't know, as certain acts, events, or circumstances which are beyond the control of the parties, for example, natural disasters or the outbreak of hostilities, and they typically excuse one or both parties from performance of the contract in some way following the occurrence of that event. It's always important when you're thinking about, delays or failure to perform, to think about whether a force majeure clause might apply, and always go back and check that clause, because they're drafted differently on every occasion. But I would say in a lot of circumstances it's unlikely to assist. So it is unlikely to apply where the cause is a prolonged period of circumstances. So for example, a hot summer or a difficult harvest, and it's not going to apply simply because performance becomes more onerous, i.e. because it's become more costly. But again, always worth looking at how widely it's drafted, and thinking about whether it might apply in your scenario. Jess, did you have any questions that you wanted to cover?
That I've had a message sent looking at how to actually start the process of if there's any formal way of providing a risk assessment of your supply chains. And there's nothing specific other than to sort of go through each aspect of it in turn. And one thing that can be useful though is to also review your internal policies and to provide a crisis management review so that you can see how aspects of your own company internally might respond to an event of whatever kind, whether it's a contamination or whether it's a breakdown of your suppliers providing the ingredients for whatever reason, and how you would actually respond to that, to really stress test how robust your internal systems are and where the gaps are, where you need to focus on with the food supply chain. So that's a useful tip for sort of how to start going about things as well. But if there's that was sent separately, but if there are any questions from any of the listeners, please do use the Q&A function, and we will have the questions pop up.
I've got another one here actually, which we get asked quite a lot, which I might be able to field now. And the question is, in those circumstances, could you just get an injunction, for example, to force the other party to perform the contract? I mean, I think in theory, maybe, but with the heavy caveat that if the company actually isn't able to supply, then that might not assist. Simply having a court order requiring them to do so, and also a bit of a health warning, because I think there's a bit of a mystique around injunctions, and that you could just run off to court and get one quite easily. Actually, to get an injunction, you need to first commence proceedings for breach of contract and then apply for the injunction. And it's what's known as an equitable remedy, which means it's really at the discretion of the judge, with a number of different elements required to be proven. There are also a number of different aspects to it. For example, you have to give what's known as a cross undertaking in damages, which means if you get it wrong and shouldn't have got the injunction in the first place, then you will have to pay that supplier's costs. And if it's applied urgently without notice to the other party, you also have something that's known as a full and frank duty of disclosure, which means you have to really disclose all the helpful and unhelpful facts, and if you fail to do that, then it is subject to sanctions. So all of those factors mean that it's certainly not for the faint-hearted, but in the right circumstances, it is something that you can do.
We've got a couple of questions in on our question and answer facility here. The first one is, for me, it's on eggs. So with the changes on eggs, does this mean free range is likely to become the norm in the EU? Well, in the EU, there will be this restriction on the caged farming. There are differing definitions on what would be free range versus sort of within a barn or other areas of what you can and cannot say about your eggs. Certainly, it would look like the caged farming would be phased out. So again, it would depend very much on what you want to say about your end product. Any positive claim would need to be substantiated. If it is a legally defined term in legislation, for example, there's the battery versus the caged versus the barn, or whether it is a voluntary statement where it's just the reasonable consumer's understanding of what it is, it does underline what positive claims you need to make about your product. And also, if there is restriction for welfare reasons in a particular country, then that would be applied, and there will be tariff requirements for any imports. And the UK would start to be different with their own trade agreement. So we will start seeing a bit of a schism there, and that will have impact for as a food business. What SKUs do you need to have? What labelling requirements you need to have? You'll start to see that the two aspects pulling away slightly, which we haven't seen too much of to date. We have pretty much followed the EU, and that might be a decision for food businesses as well. Are they going to be following the regulatory requirements of the EU, or would they even be able to do that, depending on what changes happen in the UK? We do have one last question here.
I'll try and field that in the time available, Jess. We've had a good question here. Have you seen step-in rights work? For example, where company A has a contractual right to take over the relationship with company C if B has become insolvent. And that's a really good question, actually. I think I have seen it work in the past. I think you have to have the right provisions in the contract to enable you to do that, because there's so much corporate knowledge in the middle in that company, which means that if you don't have the sort of cooperation of everybody involved and the provisions that allow you to get the information you need to step in, it can often be a bit of a mess. But with the right contractual provisions in place and the right understanding of what that company does, then it can work. But it's a question of how well you know that business and how easy it would be to step in.
Great. So I think that all that remains is to thank you very much for your attendance, and we look forward to your feedback. Thank you.
Thank you very much for joining.